Today on Legalese, we will be discussing two recent decisions from the Fifth and the Tenth Circuit that ended with the police receiving their comeuppance for two egregious violations of individual rights protected explicitly under the First Amendment. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me bid a special welcome to you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let's just jump right into it. Today, we are going to be talking about two cases in which a federal court would deny a motion to dismiss from officers who were seeking qualified immunity after they victimized citizens who had done nothing wrong. Now, the first one will deal with a citizen who was arrested by the police for daring to hold them accountable by criticizing them when they were doing things that they very well deserved to be criticized for. Though I do want to stipulate here that actually that doesn't really matter whether it was deserved or not. Criticism of one's government and the public servants who work for it is protected speech, and any policeman who punishes any citizen for any criticism is engaging in an excess of authority, to say the very least. Now, the second case we will be looking at will revolve around a person who posted a joke on Facebook and was subsequently arrested and charged with a state anti-terrorism law. Now, the first case that we're going to be looking at here is Jordan versus Adams County Sheriff's Office out of the 10th Circuit. Now, just so you know, all the cases that we discuss here and all the articles that I will be citing and things like that, you can find links to all of these documents on the show notes page. So you can find the case brief for this case we're about to talk about, as well as the other case, as well as the article I'm going to be reading from here in just a second. So just head over to the show notes page, and there's lots of good links to all the information I use here and even other good related information. So go check that out. So, as far as Jordan versus Adams County Sheriff's Office, on July 18th of 2023, the 10th Circuit Court of Appeals would file an opinion in this case. Now, fortunately, in this instance, the 10th Circuit chose to protect the rights of the individual to engage in their constitutionally protected individual natural right of free expression, rather than relying on qualified immunity to protect the police who violated that right. Now, in a great article over on the Cato Institute blog by Joshua Katz, he started out by describing it this way: a civil society might require police, but a free society requires they be accountable for wrongdoing while on the job. Too often, though, the doctrine of qualified immunity will protect officers who exceed their authority, such as by arresting citizens who criticize them, despite that speech being protected by the First Amendment. Now, fortunately, the 10th Circuit Court of Appeals would deny summary judgment based on qualified immunity in just that circumstance. And we had a unanimous panel speaking through Judge David M. Ebel, who took the step of not only finding the officer's conduct to not only violate the Constitution, but to also then be unprotected by qualified immunity. So this case starts with a man named John Jordan and his nephew, who's just identified as JJ because he was a minor. So JJ had borrowed his uncle John Jordan's truck. He had a car accident, and Jordan went to the scene to help. Now, while officers were questioning JJ, Jordan initially had been keeping his distance and just quietly watching, but eventually he grew annoyed with the way the officers were questioning his nephew JJ. He asked the officers if they were, quote, taking a statement or giving a statement, end quote, which is just a great question. I love that. However, who didn't love it was those officers who did not like their authority being challenged. And so, after a brief verbal exchange, one of these officers would very forcibly arrest Jordan. And ultimately, Jordan would be charged with obstruction of justice and resisting arrest. However, these charges were dropped. Once they were dropped, Jordan sued for unlawful arrest, malicious prosecution, excessive force, and violation of religious freedom under 42 USC section 1983. Now, if you follow my channel at all, that law should be very familiar to you. This is the law, the civil action that was created for deprivation of rights under color of law. This is the very law that qualified immunity was created to get around. And initially, that's what happened. A magistrate judge did hold that the officers were protected by qualified immunity on the first three of those claims, but not the fourth. However, the 10th Circuit would reverse all three and eventually would hold that those officers were not entitled to qualified immunity on any of those four counts. Now, the court first held that there was simply no probable cause because Jordan had a First Amendment right to criticize. Now, here they would cite the landmark Supreme Court case, Houston v. Hill from 1987. And in that case, the court held the First Amendment does not protect only quiet and respectful behavior towards police. It protects loud criticism that may annoy or distract the officer. So, since Jordan's behavior was constitutionally protected, there was no probable cause for the arrest. And further, because of this, the court would also hold, and in this they would cite an earlier 10th Circuit case, Mink v. Knox, that speech protected by the First Amendment cannot be the basis for probable cause. And they then used Mink v. Knox to find that the speech that Jordan engaged in was well within the bounds of those clearly established under First Amendment jurisprudence. Now, here, quoting from Mink v. Knox, the court said that no reasonable officer could have believed they had arguable probable cause for arrest, so there was no qualified immunity for the unlawful arrest charge. Now, the magistrate judge who had initially granted qualified immunity granted that only on the basis that the charges were valid because the officers had probable cause. So when the court reversed that particular aspect of it, that meant that the entire case just got basically thrown out. They had no more valid reason to be granted qualified immunity. Now, finally, the court would hold also that the force that was applied during, if you remember, there was a verbal exchange and then a bit of an altercation and a very forcible arrest. And in that, they found that the force applied was unconstitutionally excessive because the alleged crime was minor. They found that there was no threat to the safety of the officer or others at the scene, and that Jordan was not actively resisting arrest or attempting to flee. And in fact, what the officers called resisting arrest wasn't him attempting to flee. It was actually him attempting to remain at the scene because remember, this was his car and his nephew that he was there to help. So in this, the 10th Circuit Court would go on to cite another earlier 10th Circuit precedent from, what is it, Morris v. No, that the excessive force violation was one of clearly established law, citing Morris v. No, a prior 10th Circuit case that established physical force similar to that used here was unlawful when the arrestee poses no threats, puts up no resistance, and does not attempt to flee. All he did, again, was attempt to remain. So the court here was very obviously correct to hold these officers accountable for their abuse of power. Now, such pushback against the all too common grant of qualified immunity is always welcome as far as I'm concerned, and I'm sure as far as pretty much everyone listening is concerned. Now, what would be even more welcome would be just a complete rethinking of this textualist doctrine that the Supreme Court just created whole cloth out of nowhere, that they just magically read into Section 1983. Uh, Interestingly, which they first read into it in the year 1983 in the case of Harlow v. Fitzgerald. And, just so you know, I actually, am working on a video where I'm gonna be talking about the whole history of qualified immunity, so be looking out for that one because I think you guys will really enjoy that video, but anyways, let us move on here. So we are now moving on to, the next case. Now, this is something that I shouldn't have to say, but sadly, as you're going to find out here very soon, apparently I do. It is not a crime to make a joke on the internet. Not only is it not a crime, it can't be a crime because the First Amendment will protect speech in cyberspace every bit as much as it does in a town square, a newspaper, or a private home. However, as we know, overzealous local officials don't, let's just say they don't always honor that constitutional guarantee, to put things very mildly. Now, one example of this is one in which we are about to talk about, where the Rapids County Sheriff Office, which I'm just going to call the RCSO from here on out, would arrest one Waylon Bailey. They did this by sending a SWAT team to his home, and they charged Bailey with violating Louisiana's anti terrorism statute. Now, fortunately, the very unfunny nature of his ridiculous arrest was not lost on the prosecutor, who immediately dropped the charges as soon as he became aware of them. It was at this point that Bailey then sought to vindicate this violation of his First and Fourth Amendment rights by filing a suit against the sheriff and arresting officers. Now, in this case, the district court would grant these officers qualified immunity. However, they also went on to find that Bailey's obvious joke on Facebook was not protected speech. Now, the one of the biggest problems here is that the district court reached this conclusion by relying on two very much outmoded World War I era Supreme Court precedents that permitted the government to jail speakers based on even the remote possibility that their speech might lead to unlawful action. And ultimately, the district court would actually say that Whalen didn't have any free speech rights to make a joke in the first place. So Bailey would go on to appeal his case to the Fifth Circuit, and in his case, he would urge them to reverse the district court on the grounds that the First Amendment protects online humor and that this includes a joke posted on social media. Furthermore, he would point out that the district court had erred by relying on Schenck and Abrams. Now, these are two long discredited precedents. These are those outmoded World War I cases I talked about. And if you would actually like to learn more about these precedents in Schenck and Abrams, this is actually a topic I have covered before in a past video of mine called Sedition and American Virtue. So it's actually one of my more favorite episodes. So I will link to that on the show notes page, and I would encourage you guys to go check it out after this video. So the court should have instead, and this is what Whalen was saying in his appeal to the Fifth Circuit, the court should have instead applied the contemporary Brandenburg test for incitement. Now, this comes from the landmark case of Brandenburg v. Ohio. And the final thing that Bailey's brief explains is why An innocuous joke, such as the one that he made, cannot serve as a basis for probable cause to arrest. Now, late last week, the Fifth Circuit Court did finally hand down their opinion. So they started by looking at the facts of the case. Now, this case is Bailey v. Isles, and you'll find a link to this case brief and the full docket and all the supporting documents on the show notes page. And they recount the facts of the case like this. On March 20th, 2020, during what I'm sure we all remember was a period of great uncertainty in the very early days of the COVID-19 pandemic, Waylon Bailey would post the following message on his Facebook page. Now, as you can see, his post consisted of a faux urgent warning to his Facebook friends that the Rapids County Sheriff's Office had been instructed to shoot, quote, the infected on site. Now, one would think that just the over the top rhetoric of the post, along with the fact that it was typed in all caps text, included several emojis, and even has a hashtag that references Brad Pitt and his role in the zombie movie World War Z, would be enough to make it clear to everyone that this was a joke. And what you see is in the exchanges between Bailey and his friends who were viewing the comment and who were leaving comments on it, is that it was very clear to them and everybody that Bailey was joking around. Well, almost everybody. You see, shortly after Bailey posted that, one Detective Randall Isles was assigned by the Rapids Parish Sheriff Office, the RPSO, to investigate. This was because Isles' supervisors had grown concerned that the post was a legitimate threat. And Isles testified at his deposition that he thought the post was, quote, meant to get police officers hurt, end quote. Now, when Isles looked at the post and the comments, he concluded that Bailey had committed the crime of terrorizing in violation of Louisiana Revised Statute, Title 14, Section 40.1. So, you thought that he was engaging in terrorizing and menacing behavior. Yes. So, what do you think happens when a SWAT team comes into an unsuspecting person's house caught completely off guard with their weapons drawn? What exactly does that cause? Terror? Excellent. So, you sent in a SWAT team against the consequences of the very action that you yourself were involved in. Well, yeah, but no, ours is good terror. No, when the government does it, it's just good, peaceful, freedom loving terror. Now, Isles had no information regarding anyone actually contacting the RPSO to complain about the post or to express any kind of fear, and he had no signal that there was any kind of disruption that had occurred because of the post. And now going to the text of the Fifth Circuit decision, they find that according to Bailey, he had been working in his garage when as many as a dozen deputies with bulletproof vests and weapons drawn approached him and ordered him to put his hands on his head, after which Isles told him to get on his knees and he was handcuffed. While Bailey was handcuffed, one of the deputies told him that, quote, the next thing you put on Facebook should be not to fuck with the police, end quote. And the deputies had a very good laugh at the terror they were instilling in this poor man. Now, what I think is kind of almost hilariously ironic is that the RPSO would announce Bailey's arrest on his own Facebook page, bringing far more attention to this so-called dangerous post than could have possibly been brought to it before when it was just people who knew Bailey who were seeing it. But apparently that was lost on them. Now, furthermore, he had been identified in news reports as having been arrested for terrorism. Now, Bailey's wife was able to pay a bond and bail him out of jail, and the district attorney would subsequently drop all charges and chose not to prosecute Bailey at all. Now, the district court would conclude sua sponte that Bailey's Facebook post was not constitutionally protected speech under the First Amendment because it created a clear and present danger, equating Bailey's post with publishing misinformation during the very early stages of the COVID-19 pandemic and a time of national crisis, which the district court said was remarkably similar in nature to falsely shouting fire in a crowded theater. Now that which is one of the most famous, most well-known of all Supreme Court precedents. Now that comes from one of those two outmoded cases we were talking about earlier, Schenck v. United States. And just a interesting, fun little fact about that is that everyone always uses that quote as though it's actually usable precedent. However, what no one seems to know is that that quote came from a lone dissenting opinion by Oliver Wendell Holmes Jr. This means that this quote that everyone relies on so heavily, not only was it not part of any actual holding in the case, it wasn't even dicta. It was just part of a dissenting opinion by one judge. So people should really stop looking at that as being some kind of, famous or precedent setting standard. But, anyways, moving on. Relatedly, when it comes to that other case we were talking about, Abrams, the district court would hold that Bailey's Facebook post may very well have been intended to cite lawless action and, in any event, certainly had a substantial likelihood of inciting fear, lawlessness, and violence. And this was citing a precedent set in Abrams v. United States. However, the citing of both of these was objectively in error. Now, in concluding that Bailey's post was unprotected speech, the district court applied the wrong legal standard. You see, while Schenck and Abrams have never been formally overruled by the court, the clear and present danger test that was applied in those cases was subsequently limited by the incitement test that would be announced in Brandenburg, which was a landmark 1969 Supreme Court precedent. Now, as the Fourth Circuit has explained, the clear and present danger test from Schenck and Abrams is devoid of any such limiting criteria as directedness, likelihood, or imminence applied to a wide range of advocacy that now find a refuge under Brandenburg, such that Brandenburg has thus been widely understood as having significantly, if tacitly, narrowed the category of incitement. And in Brandenburg, the court held advocacy that is directed to inciting or producing imminent lawless action and is likely to incite or produce such action is not protected by the First Amendment. And a comparison the court made was with the Supreme Court precedent that makes clear that Bailey's post was not advocacy directed to inciting or producing imminent lawless action, nor was it even likely to incite such action. The simple fact is the post did not direct any person or group to take any unlawful action either immediately or in the near future, and nobody took any such action because of the post, and no such actions were even likely to result because the post was so clearly intended as a joke. nor did Bailey have the requisite intent to incite. At the very worst, one might be able to say that his post was a joke made in bad taste, but it cannot be read as intentionally directed to incitement. And this is why, despite Bailey's arrest for terrorizing, his Facebook post was also not a true threat, which is actually another category of speech unprotected by the First Amendment. It actually, while I'm thinking about it, a lot of people don't know that there's actually uh, five different kinds of speech not protected by the First Amendment. If you guys would like a video on what those five are and how they came to be and what they mean, let me know in the comment section. That's the video I would be more than happy to make. So let me know. But anyways, moving on here. So as I was saying, it's not a true threat, which is an unprotected class of speech. This is because prima facie, Bailey's post is not a threat. But even to the extent one could possibly say that they considered it a threat directed either at the public, trying to make them fear that RPSO deputies would shoot them if they were, quote, infected, or I suppose a threat to RPSO deputies that the quote infected would shoot back, this was not a true threat based on context because it lacks believability and was not serious, and that this is evidence clearly, but for a number of reasons, perhaps the most obvious being the clear call for Brad Pitt's character from a fictional movie to come and rescue them. And so the court also held that the law was so clear that the defendant should be denied qualified immunity for this arrest. Now, that was so as to the First Amendment, largely for the reasons we just discussed. However, the court also found this to be true for the Fourth Amendment for the reasons we are about to discuss. See, the thing is that according to Louisiana courts, the crime of terrorizing requires false information intentionally be communicated and an immediacy element concerning the false information or threat that causes a sustained fear or serious public disruption. The statute also requires specific intent, which would be the intent to cause members of the general public to be in sustained fear for their safety or to cause evacuation of a public building, a public structure, or a facility of transportation, or to cause other serious disruption to the general public. So, based on that criteria, when we look at the relevant facts that Detective Isles had before him when he decided if he had probable cause for arrest, these are the things that we can say he knew and understood at the time he chose to make the arrest. So, the relevant facts and circumstances that were known to Isles were one, that his supervisors asked him to investigate the post, two, the content of the post itself, three, Bailey was the author of the post. Four, that there were comments below the post and that he had been aware of what they said. Fifth, that Bailey had made a statement to Isles that he meant the post as a joke and that he had no ill will towards the RPSO. Six, nobody reported the post to law enforcement. And seven, the general social conditions during the early onset of the COVID-19 pandemic. Now, these facts and circumstances are not sufficient for a reasonable person to believe that Bailey had violated the Louisiana terrorizing statute. The statute's requirement that the communication have, quote, an immediacy element concerning the false information, end quote, is lacking. And moreover, quote, causation of sustained fear is clearly an essential element of this part of the statute, end quote. And here, however, there simply were no there was no facts that could lead a reasonable person to believe that Bailey's post actually caused sustained fear. It wouldn't even be enough that it might have caused sustained fear. It has to actually do it. So, because no member of the public expressed any type of concern, it cannot be probable cause. Furthermore, the court would even point out that even if the post had been taken seriously, it is too general and contingent to be specific as a threat or that harm is imminent or in progress as the law would demand. Nor, the court found, would a reasonable person believe, based on those facts I just laid out, that Bailey had acted with the requisite specific intent to cause sustained fear or serious public disruption. And so, while the district court stated that the timing of the post during the first month of the COVID-19 pandemic, what and which they note was a time of dramatic change, fear, uncertainty, and misinformation, was, in the words of the district court, quote, central and critical to its probable cause analysis, end quote. Now, the Fifth Circuit would go on to say that while the social context of COVID-19 is certainly relevant to consider, the general fear and uncertainty around COVID-19 does not turn Bailey's otherwise inane Facebook post into a terroristic threat under Louisiana law. And having determined that there was no actual probable cause for the arrest, the Fifth Circuit held that Isles was not entitled to qualified immunity because he was objectively unreasonable in believing otherwise. Believing otherwise, then, as they said in the Landmark case Stokes, officers may not disregard facts tending to dissipate probable cause, and no decision by any court contradicts that principle. And that is crucial. I want to read that again just because that is so important. Having determined that there was no actual probable cause for the arrest, the court held that Isles is not entitled to qualified immunity because he was objectively unreasonable in believing otherwise, because officers may not disregard facts tending to dissipate probable cause, and no decision by any court contradicts that principle. All right. Well, that is what I have for you guys today. Thank you so much for taking the time and tuning in. If you would take a moment for me and please do all of those things that help to trigger Al Gore's rhythm. If you like the video, smash that like button. If you disliked it, hit the dislike button. Subscribe to the channel if you want to get updates. Definitely leave me a comment. I really always do very much value reading your guys' comments and having a chance to interact with you there as much as I can. And then, of course, for more information about me or the show, you can go to the two pages whose addresses are listed on your screen right now if you want to subscribe to my newsletter or go to my homepage and learn more about me and the show. So until next time, thank you so much for watching. And this is Bob for Legalese, talking about the First Amendment and cop defendants. And of course, as always, Cartago de lenda est.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of amps, motherfucker. Like EL. motherfucker.